All right. Well, I want to invite all of you to the webinar. My name is Matt Parker. I'm one of the attorneys with the firm Marshall, Parker, and Weber. We're located in Williamsport, Pennsylvania, and we engage in elder law and estate planning. I'm here today to answer the question, why do I need a will? Why do you need a will? Why does anybody need a will? Many of you who don't have a will have probably wondered, what's the point of having one of those documents? What can it do for me or my family? So today I'm going to try and explain what the will does for you, and more specifically, what you can put in the content of your will. There are various issues that you may need to address in the will to address your various family goals you have. It may be about distributing your estate at the time of your passing by virtue of trusts or other arrangements. So hopefully I'll cover a variety of topics that will be worthwhile to you when you put your estate plan together. All right. So we have a slide presentation today, and we're going to start off talking about what is estate planning, because many people will say, do you have your estate plan together? They won't necessarily focus just on the will. So the estate plan involves more than just the document called a will. Sometimes you have a living trust, but nevertheless, there's a document that distributes assets at your passing. But estate planning is broader than that. It involves not only planning for the inevitable passing, but also putting documents together that will manage your affairs during your lifetime, typically called lifetime planning. And that might include powers of attorney, to name somebody to manage your affairs, or an advance direct, some instructions as to end-of-life care in the event you're terminally ill or permanently unconscious. The whole area of estate planning tends to be very uncomfortable for most people to discuss. Obviously, we're dealing with the inevitable end and also the potential for disability and how we're going to manage those issues. At the core of an estate plan is some sort of arrangement as to how we're going to pass on money or property at the time of our passing. It could include your home, your car, monies that you've invested, whether it's in the bank or other bank accounts. In some fashion, it's going to pass on to another person, and frequently you will need a will to do that. Now, we're going to talk about how some other monies you may have invested will have beneficiaries associated with those accounts. But at the core of an estate planning document is typically a will that directs what will happen to your money and property at the time of your death. Now, some of the benefits of putting an estate plan together. Obviously, you're going to have an ordered distribution of your affairs. You will have some sort of percentages arrangement, who's named to receive what property of yours. It helps to avoid a certain amount of chaos that can occur if you don't have instructions as to what will happen to your money and property. Each year, you may read about in the newspaper or online certain celebrities that have passed away and they don't have a will. And there's a will contest, or perhaps not a will contest, but a contest over what will happen to their various monies. Too long ago, the musician Prince passed away, and he was one of the classic cases where he had a sizable estate and did not put an estate plan together. So the court eventually had to resolve who was going to receive what from his estate. Obviously, most of us don't have large sums of money to pass on to our beneficiaries, but still, if you don't have a plan in place as to who will receive what, there's going to be fighting and in a lot of uncomfortable situations after your passing. So one of the other big benefits of putting an estate plan together, some instructions, if you will be the naming of an executor. And an executor is someone who's in the will, who will take care of paying your debts, paying the inheritance taxes, and eventually distributing the assets to the beneficiaries. That person has a lot of power, and if you name the wrong individual, again, your estate will not be administered properly. Can be a lot of hard feelings after you're gone. And I should lastly point out, there are other issues that come up in an estate plan. We're not going to talk a lot about them today, but when you're meeting with an attorney, these questions will come up. One of them will be about taxes. How can I minimize taxes at the time of my passing? What's the inheritance tax all about? How it will affect my estate? Are there other issues that need to be addressed with relation to taxes? There's also an asset protection component of estate planning. A lot of times people are worried about losing their money, their home to the cost of long-term care, think nursing home costs, and they'll want to do some asset protection planning during their lifetime. So that's often a topic that's discussed in an estate planning appointment as well. So what is the will? Sometimes called the last will and testament. It's a document that's signed by you, dated and signed by you, that instructs who's going to receive what from your estate at the time of your passing. It is, in essence, a blueprint. It shows what you wanted to have happen to your money and property. If you're married and have kids, it may distribute assets to the spouse initially and then to the kids in some arrangement. And you can leave money and property in your will under terms and conditions. You can say, my son has the right to live in my house for the rest of his lifetime, but if he doesn't want to stay there, house must be sold and divided in some percentage. There's a condition. So you can arrange all sorts of things in the will with regards to who will get what and under what terms. Now, everything that you own is not spelled out in the will. They don't have a laundry list of all of your specific items that you own. There's general descriptions of what someone might typically own. Now, if you have a very specific wish, like with regard to the house, you would spell that out. The house will pass to this person under these conditions. If you have a particularly valuable asset, like a collectible car, and you want that to go to a grandchild, spell that out. A lot of clients in this area of the state have gun collections. They want those guns to go to certain individuals. They want those in the will. Now, if you have wishes with regard to less valuable items, family heirlooms and collectibles that are not all that valuable, you typically don't put them in the will. What you'll do is mention that you may leave a separate memorandum. It's a list. On one column, you'll have the list of personal property. On the other column, you'll have a person's name. So you can leave less valuable jewelry or other items like that to individuals on a separate list. And you ask your executor to please follow the list at the time of your passing. It avoids having to redo the will every time you change your mind. Keep in mind, people do redo their wills once in a while. And if you've changed your mind frequently about personal items, you're spending a lot of money on legal fees if you happen to put all of those items in the will itself. So after the property is described, there's going to be beneficiaries named to receive the property. As I mentioned, there could be specific gifts of money to a person or an organization. You could have a gift to a charity, like a church, and you could have a sum of money maybe to give into each grandchildren. So those are called specific gifts. The rest of the estate is often called the residues, everything else that's there. Real estate, monies in the bank or other investment accounts. And those typically pass to other people or organizations in various percentages. So if you had a typical family arrangement, everything would then go to your spouse at the time of your passing and then to your children in some arrangement. Keep in mind, the lawyer will often ask, what if one person dies? What will happen to their share? You always want to build in those contingencies to the will, because the will may never be rewritten after you signed it and drafted it to a certain age. And people may pass away after you write the will. So you want to say, if my child passes away, does their share go to their children if they have children? And if they don't have children, where does it then go? To the other surviving children? So you'll want to think through those contingent arrangements. And I often see clients with older wills where they don't even mention grandkids because they were drafted at a time when their children were very young and they didn't have families. So that's a good reason to update those wills. Now, there's also in the will various people who are mentioned who will manage your estate. The executor is one of those individuals. And there may also be a guardian for young people, someone who's going to manage the money for a young person, or maybe make decisions about that young individual if the parents have died. So there could be a guardian of the person. So those are other provisions that you'll typically see in the average will, those people who have some power to manage your estate. Now, I want to pause and define what is probate and tell you how it relates to your will. Probate is this court-monitored process by which a will is admitted to the Register of Wills as the original document that's going to distribute your estate. You actually need the original. You can't take a copy to the register after a person has passed away. And if you don't know about a register of the wills, you've probably passed the office at some point during your trip to the courthouse or the court administration area of your local county. There's an office called the Register of Wills that collects the wills of deceased individuals, and there is actually a file opened at that office with regards to a deceased person who's had an estate opened due to the admission of a will. And in that file, there will be a record of what goes on. There will be notices given to the beneficiary. Beneficiaries have objections as to what's gone on in the estate. They can file them at the Register of Wills. Eventually, the inheritance tax return here in Pennsylvania will be filed there, and the state will eventually be closed up, typically via an accounting and some sort of settlement agreement with the beneficiary. So all of that is part of the file, so you can actually go down and see what happened in any particular estate. So, and there can also be contests to the will. That's where the contests take place via the Register of Wills and before the local court of common pleas. Now, probate assets are those in the deceased person's name when they die. So these assets do not have somebody else's name on them as a co-owner, or there's no beneficiary associated with the asset. Therefore, there's no way to get ownership of that particular piece of property or money or investment to someone else. Typically, accounts are frozen when someone dies. You can't get at them, and you have to go through this probate process to allow the executor to actually close out the accounts and then distribute the money in accordance with the terms of the will. Now, probate has gotten a bad name in some states, Florida and California being two of them, because their probate processes take a longer time, and it tends to cost more to go through those probate processes in those states. So typically when you talk to somebody from Florida or California, they don't just have a will, they have something called a revocable living trust that tries to avoid probate. Here in Pennsylvania, those are not as popular. You can have one if you want, but because the probate process is a lot less cumbersome, people tend just to have wills here in Pennsylvania. Now, what if you don't have a will? Let's say, well, if you don't have a will, it may not be the end of the world. If you don't have a lot of money, all you have is a small bank account, maybe you don't need a will. You can put somebody's name on the bank account, will pass to that co-owner when you pass away. So not everybody needs a will. But if you don't have a will and you have money and property, what will happen is there are rules called intestacy rules that determine who gets what. For example, if you have a spouse and some children, your spouse is to get the first $30,000 of your estate, plus 1/2 of whatever the balance might be. The kids in your marriage get the other 1/2. So it may not be what you wanted. Maybe you wanted everything to go to the surviving spouse. Well, that's not what's going to happen if you don't have a will. And if you don't have a spouse or children, it gets a little more complicated. You have to look to see if your parents are alive, because they would get everything. You don't have a spouse or children, and if your parents aren't alive, then you have to go to brothers and sisters, and if they're not alive, then everything goes to nieces and nephews. So it can get really complicated if you don't have a will. So if you don't want those rules to apply, I suggest you put a will together. Now, some of the big discussions in the estate planning appointment is about taxes, and one of those taxes happens to be the inheritance tax. Here in Pennsylvania, we do have such a tax. The tax rate is dependent upon who inherits your money and property. The spouse is at the 0% tax rate, where the children and grandchildren are at 4.5%, brothers and sisters 12%, and all others are 15%. So it's not, when it's children and grandchildren, it's more of a nuisance tax. It's unfortunate that we have to pay it, but it certainly is not going to wipe out your estate. A lot more unpleasant if you happen to be a niece or a nephew. What a will helps you do is determine how these taxes are going to be paid. Keep in mind, you may have assets that pass outside of the will, like an IRA or maybe an annuity, and those will be subject to inheritance tax. So in order to avoid the beneficiaries of those paying the tax, you'll often state in your will, I want all of the money that has to go to inheritance tax to come out of my estate. So if you have a bank account, that's where the money will be paid for the inheritance taxes. You won't have to chase down, or the executor won't have to chase down the beneficiaries of the IRA, or at least tell them, hey, you've got to pay some taxes. What the executor will do will make sure that all the taxes are paid on all of those assets all at once. Or you can leave different instructions. You can say, I want everybody to pay their own inheritance taxes. We sometimes will use a clause that says if one person got the house, and the others did not, well, the person who got the house has to pay the inheritance tax on the house. After all, they are receiving the largest asset in the estate. So you can do a lot of that in the will. The federal estate tax program, by the way, doesn't affect a lot of our clients anymore. This is the program that used to get a lot of attention in the news. Right now, the average person can exempt $11.5 million from the federal estate tax program. So I haven't had a lot of people be subject to this tax in a long time. And if you're married, that number doubles. So you have to be fairly wealthy to be subject to federal estate taxes at this moment. But if you do know someone who's subject to that tax because of sizable wealth, they need some complicated estate planning and some very unique provisions in their will. Now, as I mentioned, one of the big parts of the will is the naming of the person who's going to administer or settle your estate. This person is called the executor. The executor has a lot of responsibilities. If you've ever been the executor of an estate or known someone who has, they're the ones that have to clean out the house, get it ready for sale, put it up for sale, deal with the lawyer, close out all the other accounts, put the stocks up for sale, put everything in the estate account, pay all the debts, transfer everything eventually to the beneficiaries, and close up the estate. So a lot of work that has to be done when you're the executor. And the executors have an obligation to act responsibly for all the beneficiaries in the estate. If they don't, they can be held responsible for errors. Now, they have to be negligent, but nevertheless, they could be held responsible if there's some harm caused to the beneficiaries. So you want to make sure somebody who is very responsible is named as the executor. You may want to consider naming a professional. Banks will often have trust departments where a professional trustee could be retained to make decisions on behalf of the estate. And since they do it all the time, the likelihood that the good job is going to be done is much greater than naming an individual who's probably doing this for the first time. You can name more than one person as your executor. So you often see clients saying, I want all of my children named as the executors. That's fine. They can all decide when you pass away who's going to do what, or who's going to serve and who's not going to serve. You can't force somebody to serve as an executor. They can always step down. But you want to make sure they get along. If your kids have any friction at all, please don't name them all. Just name one and name the most responsible. And lastly, I'll mention that you should name an alternate. Name one person, but then also name an alternate. So if you can name your spouse, that's great, but name the children after that in some order. Some issues you need to deal with in a typical will. You have to address the possibility that someone who's very young, a minor, will inherit part of your estate. So there are often minors' trusts or other provisions to collect money and property that's going to pass to a young person, and that will be held and managed by an adult until they reach an appropriate age. Sometimes you will see a statutory provision in the will called the Pennsylvania Uniform Transfers to Minors Account or Act. It's a very simple way to reference a state law that says in the event money or property passes to someone very young, in this case under the age of 25, that money will be held by a custodian and managed for them until they reach 25. Money can be used for things that they need while they're young, but they don't actually get what's in the account until they reach 25 years of age. You can also use a minor's trust, operates the same way. And in fact, trusts have more flexibility. You can have them last longer than age 25. They can last until they're 30 or 35, whatever age you want. And you can put various provisions in a trust that you can't put in a custodial account, like staggered distributions of money. So you got a fair amount of money that you're going to leave to a minor, and you want a certain percentage to be given to them at age 25 and another percentage at 30 and 35. You can do that with a trust. Guardians are named in the will. Guardians for young people tend to have two jobs. One, if they're managing the estate of the young person, somehow the young person has acquired money at under the age of 18, and the guardian has to come in and manage it for them until they reach the age of 18. Usually it's life insurance or something like that, and the minor for some reason was named as a beneficiary. The second thing the guardians do is they are guardians of the person. That typically comes up when you have young children and the parents have died. Thankfully, it doesn't happen too often, but every once in a while you have young children who are orphans and there's nobody else to care for them. Both parents are deceased, and you need a responsible adult who's going to take them in and care for them. So in the will is where you would put those individuals. We're going to come in and care for your children if you and your spouse are deceased. Some of the unique beneficiaries you should think about when putting your will together. Families more and more frequently will have a disabled child or grandchild. Some of these kids will have issues like autism or Down syndrome or maybe a form of mental retardation. And they may very well be receiving government benefits like Medicaid, also known as medical assistance, and supplemental security income that's often abbreviated as SSI. Those two programs have asset limitations. So if you were to inherit a lot of money and be on one of those programs, you would lose your government benefits. You have to report the inheritance and then they would take you off. So you don't want to leave money to those individuals, at least outright. Sometimes you just cut them out of the will altogether and leave the money to a brother or sister and say, take care of your disabled brother or sister. Well, that's a moral obligation. It's not a legal one. So I tell my clients, listen, what we can do is put money in a special needs trust for your child or grandchild that happens to be disabled. And while the money's in that trust, it's not counted as being owned by them, so they can keep their Medicaid and SSI. And you can name the sibling or other responsible adult as the trustee, and they can use the money in the special needs trust to pay for things that that child or grandchild might need. So it's a great way to leave an inheritance to somebody who might have a disability and be getting one of those government benefits. And by the way, these trusts I'm talking about are set forth in your will. They're not created right now. They're created at the time of your passing and funded with some of the money you have at the time of your death. So they can always be changed. Wills can be changed as many times as you want, up to the point of your passing, obviously, but during your lifetime, you can change them frequently. You can put the trust in, you can take it out, you can change the percentages going to individuals. One type of trust that you may want to think about, depending upon your family situation, is what we call a spendthrift trust. There are beneficiaries out there that have some, let's just say, lifestyle issues. You know, they have gambling problems, drug issues, bad marriages, who knows. But once again, you probably don't want to leave money to these people outright because it could be squandered for one reason or another. So you put the money in a trust. And these trusts are, name a trustee. Usually it's a professional because these kids have some problems. And the professional trustee will decide if the money should be distributed to the beneficiary and for what purpose. The trustee is the gatekeeper. The beneficiary just can't come along and say, give me $5,000. The trustee will say, well, what do you need it for? Well, if you need, your car payment or rent payment paid, you tell me in the name of the landlord and the name of the company that's owed the funds for the loan on the car, and we'll pay them directly. So that avoids the money being squandered due to the various issues that they may have in their lifetime. And again, it's usually a professional trustee who's managing the money for those individuals. Keep in mind that not everything that you own will pass through your will. A lot of your investments will pass through beneficiary designations. Maybe you have life insurance, for example. You'll have beneficiaries listed, your spouse, maybe your kids in some arrangement if your spouse is not around. Same thing with an IRA, a 401k plan, annuities. Those are types of investments. Those will all have beneficiaries associated with it. And sometimes you'll have co-owners on various accounts or investments or even real estate. If you're married, for example, I bet you look at all the investments and assets that you have, and I bet you they're either co-owned or your spouse is the beneficiary of what you have invested in. And so that's why you often don't have an estate when one spouse dies, because everything passes automatically by these contracts to the other spouse. So you have no need for probating a will when one spouse has died. It's only when both spouses have passed away. So it's very important to go over these arrangements in these, what we call non-probate investments, make sure the beneficiaries are up to date. They could be different than the will. They could be the same as the will. And if you're doing some trust planning, like those two trusts I mentioned, you may want some of that money in the life insurance policy, for example, to go to the special needs trust. So you'll need to change the beneficiary and say, I now have a will with a special needs trust. I want 50% of the life insurance policy to go to the special needs trust for my disabled son or daughter. Lastly, the second marriages can be the most difficult types of estates to plan for. The Brady Bunch is a sort of classic second marriage scenario. You have Mike bringing the 3 boys and she's bringing the 3 girls, and they're certainly happy on this show, but in a lot of cases, these are not happy arrangements, particularly as it relates to the kids and the second spouse, if you will. The kids from the first marriage don't get along with the spouse in the second marriage. And when one spouse dies, oftentimes the relationship breaks down, and there's no reason for the surviving spouse to mention the kids from the first marriage in their will. And there's no obligation to either. You could cut out the kids from the first marriage. So you want to do some creative estate planning to make sure the clients understand that if you want to provide for the kids from the first marriage, you need to put some arrangements in your will to make sure that happens. Some examples might be a marital trust. So if, I think it was Mike in this case, he was the father, he brought a certain amount of money to the marriage. He may want some of that to go in trust for his spouse. And in this case, she might have the right to use the funds during her lifetime if she didn't have enough to live on, but if there's anything left, it would go to his 3 boys. If he brought the real estate to the marriage, which might be more likely because he was an architect in this case, he would say, well, she gets to live there for the rest of her life, but if she's not around, the house goes up for sale and she gets some of the money from the sale and the boys get some of the money as well. So those are some of the creative ways you can provide for spouses in a second marriage as well as kids from a first marriage. And you got to be careful about these arrangements because there can be a lot of hard feelings if you don't do it right. So just some thoughts as we wrap up here. In a case that you're going to disinherit a child, and you certainly have the right to do so because sometimes you're not as close with all the kids and some have had a falling out with you. So if you plan on not leaving anything to them, I often recommend you mention them in the will. You say, I have thought about my child, Steve, but I have decided not to leave anything to him under the terms of this will. And it shows your state of mind. It shows that you can contemplated him and decided to leave him nothing in the will. The child who's left out does get a copy of the will. They get notified that there's your estate, and there is an opportunity to challenge the will. So you want to make sure you don't have somebody successfully challenging your will for any reason. Now, could somebody challenge your will and be successful? Well, they're going to have good facts in order to do so. The average will that's signed in a lawyer's office, for example, is signed with 2 witnesses and a notary. And we're taking notes about what you wanted and didn't want in your will. So there's very clear documentation as to what was going on at the time you signed everything. So those sorts of meetings help cut down on these claims that you were influenced to sign the will. You didn't know what was going on. So having the proper protections, that is the witnesses and the documentation, helps avoid challenges to a will. Most will challenges are signed under some very suspicious circumstances, like somebody gets a will off the internet and it's signed on a person's deathbed and they brought the neighbors in to witness the document, or maybe you don't have any witnesses at all. So average will challenge does not survive, particularly if you have enough documentation to challenge the claims that it was signed under questionable circumstances. When do you review the will? Typically, the person who does a will do so when they're young and they're just starting out. Maybe they're just starting with a family. And then they probably won't do another document until they reach retirement age. Pretty classic scenario. And then after retirement, they'll tend to look at their will more frequently. And I tell people to look at the wills about every 5 years. And if any of these issues have come up, there's health changes, maybe your spouse has developed dementia, you may want to take a look at the will then and see if we can do some things, again, with trust planning to help protect your assets from the nursing home costs. The death of an individual happens, disability issues, divorces. I just had one the other day where a client got divorced and wants the son-in-law to be taken out of everything. So it's the client's child who got divorced, and the son-in-law had to be removed. So every 5 years after you've reached the age of retirement, take a look at the will and make sure it's consistent with your wishes. And lastly, let's not forget those powers of attorney. I mentioned them in the first part of the presentation. They are signed at the same time you sign your will. So you usually have two powers of attorney, one for financial decision-making, the other for healthcare. With powers of attorney, you can really be creative. You can say either or, for example. I name this person or that person to be my power of attorney. You can't do that with a will, with executors. They have to be always have to work together as executors or trustees. And so you can name somebody to make financial decisions for you. You can have a power of attorney that for financial decision making is very broad in scope or very narrow, that is conservative. So you can do a lot of things in terms of how far you want to give somebody power to manage your affairs during your lifetime. Healthcare powers of attorney, you are incapacitated and you can't communicate to the doctor about your healthcare, so someone will be doing that for you. Typically, it's your spouse if your spouse is alive, and then it's the kids in some arrangement. Or, yeah, you can do a variety of different things with these documents, and there's often an advance directive. Those are instructions for end-of-life care if you happen to be terminally ill, permanently unconscious, or you're in a coma or vegetative state. These instructions will tell the treating physician whether you want heroic measures to keep you alive, such as ventilators and feeding tubes, or whether you just rather have comfort care. And that's blended with the healthcare power of attorney. So always make sure you do those at the same time you are doing your will. And that brings us to the end of the webinar on why do I need a will? Hopefully I've given you some insight as to the practical reasons why a will would be helpful for you. So as you put your estate plan together, think of some of those items. If you want to learn more, visit our website at paelderlaw.com. There's lots of blog articles about estate planning. And you can also sign up for our email newsletter. With that, thank you very much for attending.